Now I'm going to turn it over to Melinda and Holly to introduce themselves and to talk to you about not being HIPAAchondriacs.
Thanks, Liz. This is Melinda Maher, and I'm a partner here at Dorsey and Whitney. And welcome to our presentation of Don't Be a HIPAAchondriac, Prepare for Phase 2 HIPAA Audits. I have with me my colleague, Fistler, to whom I'm indebted for these slides. And we're just going to take you through this. We have a lot of material to cover, so we'll move through quickly. It was really prepared for an hour-long presentation, so we're going to probably move through some of these rather quickly, hoping you can get the information directly from the slides. Because what I really want to cover are the audits, which I'm going to turn over when we get to that to Holly. So you'll see in our overview generally what we want to talk about and what we want to cover, but primarily we want to get to the audits. Let me talk to you just briefly about the penalties. So the penalties are substantial. You'll see that on the slide. I guess we're on slide 38. And we still have criminal penalties associated with HIPAA violations, and the civil penalties have gone up. They went up in 2009 after the HIPAA Act was passed. But really, I think the primary takeaway from this slide is that you have public relations penalties. Just the violations of HIPAA now are much more public, whether you have to notify of a breach or whether you are audited and there's some sort of enforcement action from OCR. And OCR is the Office for Civil Rights, and they are the enforcement arm of the Department of Health and Human Services, and they are the ones who are auditing, and they are the ones who are enforcing HIPAA in addition to the state attorneys general, which we will talk about later as well. We've had a couple of prominent recent breaches, which we mention on the slide, and if you're interested in those, you can go to the websites that were mentioned there. And I think it's important to remember that if you are the subject of a breach, if say your employer-sponsored group health plan is the subject of a breach, that you should not only think about HIPAA, but think about the state law requirements that might apply to notice obligations. Some background we have on the next slide. HIPAA was passed in 1996. Really significant changes were made in 2009 after the HIPAA Act, and that's where we got this audit program, which we're going to focus on today. And then when we got regulations for privacy in 2003, security in 2005, and then we got really the breach notification regulations in 2013 as a result of HIPAA. Some important terms that we talk about in HIPAA, and I think probably most of you who are listening in are familiar with all of those terms, but remember when we talk about the rules, we're really referring to the privacy rule, the security rule, or the breach notification rule. So I'm going to turn it over to my wonderful colleague, Fistler, who knows all about HIPAA audits, and she's going to tell you a little bit about what happened in phase 1 of the HIPAA audits and what we think will happen possibly, or what to expect for phase 2.
Thank you so much, Melinda. Well, what we're going to dive into right now is lessons that we've learned from the HIPAA phase 1 that started in 2011 and concluded in 2012. They broke it up into 3 parts with the goal of developing audit protocols, so the different kinds of documents and questions that OCR would be asking during the audit process. The second step is they went through and did a sample group of covered entities to be able to test the protocols, work out some bugs. And then finally, in step 3, OCR audited 115 covered entities of different sizes, geographic locations, and types. And it was broken down into roughly 47 health plans, 67 healthcare providers, and the rest were healthcare clearinghouses. Following the conclusion of the phase 1 pilot program, OCR prepared a written report to Congress in order to publish its findings and basically to discuss what they learned from this audit program. One of the primary things that they learned is that 11% of covered entities, that is a typo, or approximately 13 of the entities, they didn't have any HIPAA compliance issues following the audit. That's a really small percentage. And approximately 2/3 of the entities did not have a completed risk analysis. Risk analyses are those written documents that go through and categorize all of the information that you receive, how you're addressing risks. And that's also a requirement, and 2/3 of the entities did not have them.
And Holly, that's a requirement of the security rule, correct?
That is a requirement of the security rule. And actually, the security rule issues accounted for 60% of those findings and observations. What they also did notice is that smaller entities had more issues than larger entities. As you'll see from the slide, some of the top privacy rules included the preparation, distribution of compliant notices of privacy practices, making sure individuals had access to their own PHI, whether it's medical records or health plan documents, authorizations for disclosure, making sure you have it in writing that you're allowed to use and disclose that information on behalf of those individuals. Security rules really and truly dealt not only with the documentation of the risk analysis, but also dealt with the fact that in an increasingly mobile and electronic age, policies and procedures need to be in place for storage media and making sure that ePHI, or electronic protected health information, is controlled and monitored. And with long-awaited and bated breath, we realized that the Phase 2 program was launched in March of this year, and they are going to be auditing not only covered entities, but also business associates. So this is the first time that business associates are being included in the audit program. And as with the last time, they're going to have a nice sampling of the different sizes and types of entities.
And that may be a result of the business associates being added directly to HIPAA, essentially by the HITECH Act, right, Holly?
Exactly.
Okay.
Great point. It's OCR's way of trying to ensure that all of the different entities that are now subject directly to privacy and security are being taken into account and being audited to make sure that everybody is, keeping up with all of the recent changes. Now, Phase 2 is going to consist of 2 rounds of desk audits. So this is going to be kind of a back and forth of information and questions and documents, and they may be followed by on-site audits. OCR is hoping to wrap this up by the end of the year. They have also updated their audit protocol. Remember, they had established it during Phase 1. This one is a little bit different than the last version insofar as it's less of a tell me what you're doing and more of a show me. So proper documentation, policies, and procedures are going to be key. As part of the audit process, we've been hearing from our clients and industry colleagues. OCR is first sending out an email to verify the covered entities or business associates' contact information. This is going to come in the form of an email. And then this will be followed by a pre-screening questionnaire with different questions to find out more about the entity, size, location. If it's a group health plan, kind of the numbers of claims, use of TPAs. The recommendation is to really and truly check your spam filters just in case you haven't received one. The other thing that we've heard as well is that the contact information may not always be correct. So your entity may have received an email, but it may have gone to the sales department instead of the human resources department. Some entities have actually received multiple emails on these topics. But the goal is really and truly you need to fill these out and make sure they get sent back in. Otherwise, OCR will use publicly available information in order to fill out these processes. The pre-screening questionnaire is going to be used to help narrow down and select the final pool of auditees. If you do get audited, you will be going through the established audit process that we have summarized here on this slide. Notice that there are the very short time frames for responding. From Phase 1, we understand that there is some general flexibility when working with OCR. Once it's assigned, you may be able to negotiate and get extensions as necessary.
And one thing I would point out, Holly, about the pre-screening audit was we did hear from some people that it wasn't always clear what entity OCR was inquiring of. Is that consistent with what you've run into? That is consistent. And in fact, when you sometimes have entities that have more than one function, so for example, take a large pharmacy company. They are a healthcare provider as a covered entity. But on the other hand, they also sponsor group health plans for their employees across the country. It may not necessarily be clear either from the contact letter
or from the questionnaire itself, which entity is actually being questioned. Now, some people we've heard, the letters are actually very clear. They're talking to the group health plan. They've named the group health plan. Others, it's less clear, and they may not have named which entity they're looking at. OCR does have an email for entities to send in questions. I haven't heard of anybody yet that has used that, and whether or not the time, the turnaround time will match what they're requesting.
Oh, and just to back up a second, Holly, we did talk about that very tight time frame on the audit process, the 10 business days to respond. And there is some suggestion that maybe there may be some leeway there, although we don't know for sure, I think, with phase 2 yet whether there will be.
No, I think it will depend on the situation. It may depend, too, on the reviewing agent. It may depend on the type of information that is being requested. I think, too, the tight time frame may have to do with the fact that they would like to get this wrapped up by year end. Not to mention the fact, though, there will be a third round of desk audits, depending on what they come up with during the first, on-site. Excuse me, there will be a third round of on-site audits depending on what they find out during the desk audit. So if there's anything that causes concern, or if there's anything that OCR determines needs further investigation, they may push it into a desk audit, and that could last into next year. And at the end of the audit, just like with phase 1, what happens is that from the final report, there will be recommendations for corrective actions. Technical assistance may be offered as necessary to help the entities be able to fully comply with HIPAA. If there's a serious issue, OCR may push it into compliance review to further investigate. What we will go over really briefly is that in addition to the audit program, there are 2 other enforcement activities that are going on simultaneously, and these go on all the time. First of all, under HITECH, the attorneys generals of the different states have been authorized to bring civil actions for privacy or security violations. They've been offered training from Health and Security, the Department of HHS. They can collect damages of up to $25,000 per violation per year. This is limited, and it is a little bit less than what we've seen on as far as the regular HIPAA penalties. But if a state is going to bring a civil action, they do need to serve HHS, and HHS may get involved. As an example, state attorneys generals have been active in HIPAA enforcement, and again, the trend is really towards reaching a settlement. All of these are different settlements that have been reached, and they usually involve penalty, corrective actions, and monitoring. And you can take a look at some of these different examples kind of on your own time to see, exactly what happened.
And I would just point out there that there's a number of those that involve unencrypted portable devices, which we have seen are definitely a problem.
And finally, the other branch of the enforcement involves investigations and compliance reviews. These are triggered when an individual brings a complaint to the Department of Health and Human Services, or through breach notifications or referrals from the audit program. This is a more in-depth analysis that is conducted by HHS, investigating, finding out whether there have been possible violations and what type of corrective action needs to happen. OCR has emphasized on its website, though, that their goal is systemic change. Their goal is compliance, and at the end of the day, making sure that not only is the individual protected, but that the entity's actions are correct going forward under HIPAA. A sampling of the compliance resolution agreements just since March of this year have yielded quite high settlement penalties for different kinds of breaches. But I think the moral of the story here is, even on these last 2, is it's important to know who your business associates are and enter into agreements with them.
Yeah, and we'll talk about that a little bit later, but I do think that is very significant. I see that as a very significant development, that they are really, that the regulators and the state attorney general both are focusing on that. so we'll move on to just a little bit of discussion of what you can do to make sure you're prepared for the audits. And part of that is just to know what kind of a covered entity you have. And we're speaking really, in this case, to employers. Employers who sponsor group health plans. It's important for them to know, for example, are you self-insured or are you fully insured? That makes a significant difference in terms of your compliance responsibilities. And certainly you need to know which of your group health plans are subject to HIPAA, and we've listed examples here on this particular slide. Don't forget dental, vision, things, wellness programs. Don't forget about those types of plans and programs. So once you've established whether you're fully insured or self-funded, you also need to determine whether you're fully insured and you don't get PHI, and we've kind of classified that as hands-off, or you're fully insured and you in fact do get protected health information, in which case we've classified that as fully insured and hands-on. If you're fully insured and hands-on, essentially you are like a self-funded health plan and your compliance obligations are similar, if not the same, as a self-funded health plan. I typically see fully insured and hands-off. To me, it's unusual to see a plan that is fully insured and gets PHI, primarily because the carriers are not accustomed to that. That is not a model that they are normally familiar with, and they're somewhat resistant to it. And also because a lot of fully insured employers don't want the compliance obligations that come with that. And once you establish, so really let's remember too that you may think that you're getting de-identified health information and therefore you're fully insured and hands-off. That's a fairly high bar. When you're fully insured, you are also entitled to get summary health information, which allows you to get a little bit more information than purely de-identified, but still not much. So make sure that you're, in fact, you and your carrier are in agreement that you're not getting really protected health information or summary, and the only information you're getting is summary health information. If you establish that and you're fully insured, then your privacy obligations essentially go way down. And on this particular slide that we have on the screen, we show you some best practices for if you're fully insured and hands-off. And then we'll move on to self-insured or fully insured and hands-on. Here are your privacy obligations, and they are significant, and this is what you will be audited on. So make sure that you are doing the things that we have listed on the slide as your privacy compliance obligations. The other issue to ensure that you are paying attention to is your business associates. And we've listed some common examples of business associates, third-party administrators, anyone you use for, say, data analysis, often brokers. Even your lawyers can be a business associate if, for example, they may be helping you on a claim or an appeal. And we touched on this earlier, but really we have seen quite a bit of enforcement in terms of business associate agreements. So it's really important to identify who your business associates are and make sure that you are getting the proper agreements with them.
And Melinda, isn't it true that with the enhanced definition of business associates, this list of entities that could fall under this category has become larger?
Yes, that's exactly right. Thank you, Holly. HITech did expand the list of who can be a business associate and includes cloud storage vendors, third-party IT providers. So take a hard look at that, particularly after we've had the amendments to HITech. In turn, if you are in fact a business associate, you'll want to have your own business associate agreement that you can offer to your covered entity clients. So we in the next slide, we talk about how important it is. Again, let's just emphasize, you need to make sure you have a business associate agreement. I would say typically if you're fully insured and hands-off, my hope would be you don't need to have a business associate agreement. Really, it would primarily be those who are self-insured or fully insured with hands-on PHI, getting PHI. And then we've listed for you what the required BAA provisions are, and there is in fact a business associate agreement template that you can use. We recommend, though, that you would actually create your own And I've moved on to the next slide to point out to you that there are a number of provisions that are not included in the template, but that we think are really critical for you to address in your business associate agreements. And I'll just pull out a couple of them. In particular, the time frames for notice in terms of breach is really critical to address, and who will provide the breach notification is also critical to provide, and often the source of contention and negotiation in these agreements. Depending on the relationship, our employer plan sponsors may want the business associate to provide the notice with respect to a breach that occurs at the business associate, or they may want to do their own notification, although in either event, they normally want the business associate to pay for the notification expenses and any sort of mitigation that might result from a breach, for example, if credit monitoring is in order. And finally, I would say indemnification is very critical to have if you can get it in your business associate agreements, particularly as the employer plan sponsor, asking for indemnification back from your business associate vendor. And finally, maybe one more item to address on this slide is the data aggregation piece. We've seen a lot of business associates who de-identify the PHI and then utilize it, perhaps aggregating it with other data they have. And we think it's important for our employer plan sponsors to know about that, to consider it, and to decide if that's something you want your business associate doing or not. So I'll turn it over to Holly. I'll turn it back to you to talk a little bit on the privacy documents, if you would.
Definitely. We touched on this a little bit earlier as far as the different responsibilities with respect to whether or not you have access to PHI. So if you've really determined that you are a self-insured plan or you're a hands-on fully insured plan, there is a list of documents that really need to be up and running and ready in case you are selected for audit or you're asked for these. One of them includes policies and procedures. Your privacy policies and procedures I liken to IKEA instructions. They're not really interesting to read all the way through from A to Z. However, they provide an incredible roadmap to know, when can I send out this information? What do I need to do if an individual is asking me for their information? And how do I address a complaint about the use of information? All of the policies and procedures contain all of this information, and you need to have this in place and ready to go. Notice of privacy practices, these are distributed to participants at least every 3 years or upon renewal. And what we've seen with the audit protocols this year is documentation showing how the plan sponsor has used and disclosed PHI, how they have responded to requests. So making sure that there is a log of different activities or if they have been asked to use or implement any kind of HIPAA rule. HHS is very interested in that. Show me, don't tell me. In addition to the privacy rule documents, there are also security documents. Now, the content of your security documents is going to vary depending on the type and amount of PHI that you're going to receive as an entity and how your group health plan is structured. In most cases, what we see for our group health plan sponsors is that there is a reduced set of security rule requirements, including, appointing your security officer, performance of the written risk analysis, development of risk management procedures, business associate procedures to make sure that your BAAs are compliant with the security rule, and periodic evaluations. And speaking of that written risk analysis, this is actually a key security document that HHS has identified as not only being lacking during the first phase 1 audits, but it is brought up significantly in those compliance statements that they issue following investigations and compliance reviews. The analysis goes through and is basically a bird's eye view of what your group health plans do with the information. Where are the risks? How critical are they? And what are you doing to mitigate them? Now, HHS on the healthit.gov has developed a sample for healthcare providers for small to medium size. It's not necessarily directly helpful for group health plan sponsors, but it provides a great idea of what they would be looking for when looking at these risk analyses.
But certainly group health plan sponsors should be at a minimum doing some sort of risk analysis here, right? And if they follow that template, that gives them, at least they're getting started.
Exactly.
Okay.
And actually it may even be more in-depth because it's designed for providers than it would be just for the group health plan sponsors, because as we saw from the previous page, the group health plan sponsors are generally required to comply with fewer of the standards. They are excused because the group health plan is the one that is holding that information.
Okay.
At this point, we're going to take a quick look at electronic media. This is a really big topic area right now for not only Health and Human Services, but the National Institute of Standards and Technologies, or NIST, as far as really and truly securing those electronic records on your mobile devices. And according to NIST, any data that isn't protected on mobile devices is vulnerable. They have actually just developed the Securing Electronic Records on Mobile Devices document and are taking comments and further developing that. What should plan sponsors be thinking about? This entire list right here, and I think the first question of all and the most important is, may your employees access HIPAA in their mobile devices? If the answer is yes, then really and truly analyzing each different step here, calling out, for example, the ability to encrypt HIPAA on those devices, remote wiping or disabling. What are your policies for holding on to those documents when you leave the office? Those kinds of questions. There should be policies in place that address each and every one of these different categories. And with that, I'm going to turn this back over to Melinda for our HIPAA Health Checkup.
Okay, thank you, Holly. So we've only got a couple minutes left, but here are a couple of suggestions we have for your HIPAA checkup. Start by determining your response before a breach occurs. And I can't tell you how helpful I have found this for some of my clients who have had to scramble after the fact to determine what to do in the event of a breach. So we've made some suggestions for what you can do in advance of a breach. And then, in fact, at the bottom of the slide, consider defensive strategies. So consider trying to prevent a breach. My own sense is that a breach will probably be inevitable. You can minimize it, and depending on the type of organization you are and how much PHI you have, it's probably inevitable if you're a big organization with a lot of PHI, but try to minimize the fallout from it. And certainly encryption is how to minimize the risk of a breach. And it is encryption within the NIST standards. And certainly with respect to mobile devices, I think depending on the type of organization you are, I think you're going to be hard-pressed to justify no encryption, particularly on mobile devices, if in fact you do have a breach. And cyber liability insurance is a great consideration as well, depending on what type of an organization you are. And finally, we're going to end with our 3 action steps to check on your HIPAA health. First of all, if you're an employer, in particular employer plan sponsor or other covered entity, have you issued a notice of privacy practices? Make sure you're doing it. Make sure it's up to date. Make sure it's accurate with respect to what you do. Please look at your business associates, do an analysis of who they are, and make sure you have business associate agreements in place. And the other thing to do is make sure that they have been updated since the changes as a result of high-tech in 2013. And finally, who is your privacy officer? Make sure you have one so that when HHS and OCR come in and ask who it is, you have a name, you have somebody who's doing that, they know that they're the privacy officer, and please make sure that you are doing your training. And if you do nothing else, that will help. And I think that's all we have.
Wow, great. Thanks so much, Melinda and Holly. Terrific presentation.